Hello, it is another episode on the Elite Law Training, and this is our last part on Criminal Law Practice Series. My name is Folake Mijegede. We'll be discussing the role of the prosecution in the administration of criminal justice system in Nigeria. As we all know, that the administration of criminal justice system is like a triple stand, and this includes the defense, the court, and the prosecution. And each party must perform their role according to the requirements of the law. General supervisory power and control over criminal prosecution is vested in the Attorney General of the Federation and the Attorney General of the State as provided for under Section 174 and Section 211 of the Constitution, respectively. There are some agencies, however, that have been vested with the power to also prosecute matters at every point in time, such as the Nigerian Police Force, the EFCC, the ICPC, the NDLEA, and so on. However, all these agencies are still subject to the supervisory power and the control power of the Attorney General. Oftentimes, we see private persons also granted fiat to also prosecute criminal matters. But always remember that it is the duty of the prosecution to prove the case of an accused person beyond reasonable doubt. Therefore, the outcome of every case depends on what has been done by the prosecution. So importantly, what is the definition of a prosecutor? According to the Black Law Dictionary, the 8th edition precisely, a prosecutor is defined as a legal officer who represents the state or federal government in criminal proceedings. Therefore, I'll expatiate that whether you are a private person, whether you have been given fiat, whether you are working with any agency, you represent the state and you are a prosecutor. I like this next definition. According to the American Bar Association, they define prosecutor to be an officer of court or a minister of justice. Wow, this connotes that as a legal officer, you are supposed to be a minister of justice. So, it's clearly shown that it is not about winning or losing, where you see convictions sometimes as win and acquittal as your loss. Oftentimes, I always wonder when you see prosecutor feel bad or feel sad when they lose a matter. Getting convictions or getting acquittal is not a matter of what you should base your practice on. What you should do after each case is to ask yourself that, have you ministered justice in this particular case? And if your answer is in affirmative, then you've done what you are supposed to do as a minister of justice. Even though we don't have a codified general provision for the prosecution to state their code of conduct, however, we all know the function of a prosecutor is crucial in the administration of criminal justice. And we formulated their role into 4 cogent parts. The first one is duty to seek justice. Justice is not always to seek conviction. We should always know that. Justice must be seen to have been done by the state, by the victim, and even the accused person. Oftentimes, prosecutors always say that justice is done to the victim, but sometimes they forget to check or to make sure that justice is also done to the accused person. For example, his right to fair hearing. Did they comply with the Section 36 of the Constitution? Did they avail to the defense proper information and documents for him to prepare for his or her trial? Did they disclose relevant exculpatory and inculpatory evidence to the defense team? That is not a case of nailing for conviction, but is always a case for ministering of justice, so that at the end of the day, the innocent person will not be convicted for what he or she has not done. And the second point is that always ensure proper functioning of administration of criminal justice. At every stage of the prosecution process, there is a major role on the prosecutor to make sure that the administration of justice is functioning well. From every stage, that is from the beginning of every prosecution process, from the time of arrest to the time of remand, to the time of trial, to the time of conviction, to the time of sentencing. A scenario that somebody has been in custody for like 4 years awaiting trial, and you filed for enforcement of such person's right, or bail for such person, or unconditional release for such person, and you see a prosecutor filing preliminary objection based on technicalities, instead of the prosecutor to find out why the person is still in custody unjustly, or what has happened that the person has not been tried before a competent court. I see it as a misplaced of role. If you don't know that your role as a prosecutor is to make sure that justice is served, to administer justice at every point in time, and this emphasis was laid in the case of Suleiman against COP. And the number 3 is duty of fairness. The rules of professional conduct of legal practitioner, particularly Rule 32, place a high standard of fairness on parties in the conduct of criminal cases. Prosecutor is not a persecutor. Therefore, at every point, they must make sure that there is fairness in their judgment. It is very unprofessional to suppress facts or keep secret a witness capable of establishing the innocence of the accused person, and at the same time also of convicting the accused person. You must be fair in all your judgment. If you have a witness that will exonerate the accused person, then bring it on. If you have a witness that will convict the accused person to show that the accused person actually did the offense, then bring it. You must be fair. So it's not only about you convicting the accused person. If you also have the exhibits or evidence to exonerate his or her innocence, then you must always bring it. Don't suppress any fact. The fourth one is duty to avoid conflict of interest and impartiality. This is very important. Don't be impartial. Don't be stiff. Because you do not have a relationship with a particular defense counsel does not mean that you should always victimize such defense counsel in court. Let there be a playing ground field for every lawyer. Don't be counting scores against any defense counsel. Your roles are different. You are a minister of justice. Your conscience must be clear that at the end of the day, justice has been done, not that conviction has been made. This will bring us to the end of the criminal law practice series. I hope you've been learning one or two things over time. As a defense counsel, as a prosecutor, we can do better in our area of practice. Thank you for joining us today. Kindly subscribe to our YouTube channel at The Law and High, and follow us on Facebook at The Law and High, and also follow Kemi Jegede on Instagram and on Facebook. Thank you and God bless.